Welcome once again to Lehto's Law. Here's Steve Lehto.
This is another one of those stories sent to me by almost everybody, so I got to thank almost everybody for sending it. But it's one of those conundrums. It's a story where there's a lot of confusion, and people wonder what the thought process is. What's the rationale behind how this turned out? And it is an unusual case in that respect. But in Florida, a law was recently passed by the legislature and put into law that says that HOAs cannot put restrictive things in their rules, for instance, to keep people from parking, pickup trucks in their driveways overnight. And so everybody who's got a pickup truck who lives in an HOA that was being enforced like that breathed a sigh of relief until many HOAs apparently sent out notes and letters and said, oh, by the way, it doesn't apply to us. Wait, what? It's a law in Florida. The HOA's in Florida. Why wouldn't it apply to you? Well, the way the law was written, and there's a reason they wrote it the way they did, which is going to strike as an unusual thing to a lot of people, but from abcactionnews.com, they're one of the outlets that covered this very well. Adam Walser wrote, subdivision continues fines and towing after Florida HOA law banning parking restrictions goes into effect. So there is this situation where a lot of HOAs ban pickup trucks and work trucks from parking in driveways. Now, keep in mind, those are two different things. A pickup truck, we're talking about just a civilian pickup truck. But a work truck might have advertising on the sign. It might be huge, but pickup trucks. And the law went into effect July 1st, and already at least one HOA out of Sarasota is saying that it will continue to hand out fines and tow vehicles under the existing regulations, notwithstanding that silly law that got passed. So the I-team at abcactionnews.com is trying to figure out what's going on here. And they interviewed a guy who's got a 2014 Chevy Silverado pickup. And he says it's functional, hauling things most of all, and also as an extended cab. I do have a wife and daughter, but his truck won't fit easily into his garage. And he says, I cannot park my own truck in my own driveway. The subdivision, called the Meadows, doesn't allow pickup trucks or commercial vehicles in their driveways between 11 p.m. and 5 a.m. So this window of time cannot be parked there. It turns out that there's a safety patrol that goes out at night and looks for violations, and if they see a pickup truck or work truck in your driveway, they'll send you a warning letter, and then they can fine you. And they might actually have your vehicle towed out of your driveway. Now, the man admits that he agreed to live by rules when he moved into the neighborhood back in 2019, but he hoped that this new law would change that. And he said, you can imagine how ecstatic I was when I heard I can park it at my own house. He and his wife have to make twice daily trips to drop off and pick up his truck at a fenced-in lot about a mile from their home, a little bit less. And it costs him, and his neighbors, by the way, who are doing this also, $500 per vehicle per year to park in that other lot. And of course, they got to get back and forth. So the man says, we all know each other. We see each other every night and every morning. If you come back at night, it's full because everybody's paying to park in here, which some people are probably going to go, Steve, is there a financial incentive for somebody to keep these laws on the books or keep these rules on the HOA books? So another woman was talking about this, and she's got a $200,000 custom Mercedes van. And she says that she and her husband, who has a pickup truck, have got to park both their vehicles in that other lot. Now, the new law passed by the state of Florida says homeowners association documents, including declarations of covenants, articles of incorporation, or bylaws, may not preclude a property owner or a tenant, a guest, or an invitee from parking his or her personal vehicle, including a pickup truck, in the property owner's driveway. So that's what the law says. It says homeowners association documents may not preclude this. Now, you're going to say, but Steve, that sounds like the documents preclude this. Well, here's the issue. The documents that these people agreed to were existing before this law got passed. And so the question is, does this law apply retroactively to these agreements, or is it only going forward? So going forward, if somebody right now is developing a development and they're going to have a homeowner association in place and they want to put stuff, into the rule books, they cannot preclude somebody from parking a personal vehicle, including a pickup truck, in the property's own driveway. No question it will apply from this date forward, or July 1st forward. However, the question is, does it apply retroactively to the rules that were in place, say, back in the 70s or 80s? So Meadow residents received an email days before the law went into effect that said all current parking rules and regulations will remain the same. And so the people being interviewed here said, wait, what? The general manager for the Meadows Community Association declined an on-camera interview, but said in an email the application of the new law depends on the governing language of the community association and the time it was recorded because of a reference to what they call the Kaufman language. The Kaufman language. And the Kaufman language is language that came from a case called Kaufman. So we'll get that in a second. But some restrictions have what's known as Kaufman language. And an attorney interviewed by the TV station said that some HOAs incorporate language that says, as amended from time to time in their bylaws and other documents, which is indicating if the legislature changes a statute, then the change will apply. But most homeowners associations don't have that language, and neither does the Meadows. So as a result of that, you're stuck with what was in place back at the time that the contract was entered into originally, and the law is not in the books, of course, but the HOA rules were on the books first. So the people they interviewed, the TV station interviewed, all said they're going to abide by the rules because they have to, because it's getting expensive not to. The TV station spoke to one guy who said he was threatened with $5,000 in fines, and he had to go to court, and as part of that process of making that go away, well, they agreed to waive those if he stopped parking his truck in his own driveway. So the Kaufman language comes from a case out of 1977, Kaufman versus Scheer, which affects governing documents for HOAs. And the Kaufman language specifically addresses whether the documents, the rules say that, we'll follow these rules, or we'll follow these rules as amended from time to time. And it seems like a real minor distinction. And the attorney says without the Kaufman language, existing HOA rules can still be enforced under the idea that homeowners agree to follow them when they move into the community. Because, and he says, it's much like a contract. Generally, the legislature, after a contract is entered, can't change the contract. And that's what I've talked about before. And a lot of people, I don't think, quite grasp this, or they think it's unfair. And don't get me wrong, I think this rule is unfair. However, presumably when you buy a home in an HOA, you have an opportunity to see the HOA rule book. And I know people who've said, but Steve, I bought a home, I didn't know this existed. Well, it depends what state you're in as to what kind of disclosures are required by law. But in Michigan, for instance, they ask you on this required disclosure form, is this home in an HOA, yes or no? And if the box is checked yes, you should know that, okay, I should probably go take a look at those rules. And now, what you need to understand is those rules are built into the deed to that property. So when you buy the property, you're buying into this notion that there's a contract with a bunch of rules that you need to follow. And contracts are one of those things where consenting adults can enter into a contract for a legal purpose, and courts generally will not disturb that. And so when the legislature was discussing passing a rule about HOAs and their bylaws, somebody, I presume in the legislature who may have been an attorney, said, you understand that if we pass a law that says we are retroactively changing all of these HOA covenants and agreements and rule books, that's going to get fought in court and it'll probably get overturned. Because they're going to say, what right does the legislature have to step in and rewrite contracts that people entered into 10, 20, or 30 years ago? So you may have heard on occasion where a court will step in and modify a contract or award damages to somebody who's breached a contract, but very rarely will they step in and say, okay, we're going to change this contract because we've decided it's not fair. Well, presumably, you got parties on each side of it, at least at one point, who agreed to enter into that contract. So that's what this boils down to. And I've had people give me some great examples of times where this reasoning kind of goes out the window. And so, for instance, let's suppose there's an HOA and a bunch of homes, and you're going to do your research. Someone told you, by the way, there's an HOA that's affiliated with this, so if you buy in, you're stuck with these rules. Let's suppose you do your research and you find out that everybody in this HOA is happy, it's run well, it's financially sound, and they enforce the rules only when the rules are really, really badly broken. And everybody's kind of happy about that. And so you buy the house, the home. You're now a homeowner in a homeowners association. And you're in the HOA. And they have elections every year or so. And they've got a board, and they've got somebody who runs the board. And there's a little bit of change in the makeup of the board. A couple people who are busybodies, nothing better to do with their time, get on the board. And next thing you know, there's a regime change. It used to be that they'd meet once in a while, go over the books, and go home. Now suddenly they're patrolling the neighborhood with safety patrols at night going, oh, there's a pickup truck parked in that driveway. That's a violation of the rules. And so one thing you have to remember, and this number changes wildly from time to time, but I got the data from 2022, just a couple of years ago, and I know it's changed a little bit. The economy causes this to change. But in 2022, 1 out of every 5 brand new vehicles sold in America was a pickup truck. 1 in 5. 20.5% actually. Just a tad over 1 in 5. So a lot of people buy pickup trucks. And so don't get me wrong. I've seen some pickup trucks that are in rough shape, okay? I live in Michigan. We've got vehicles here that rust out within years of hitting the road. I've seen some pretty rough pickup trucks. I've also seen some pretty rough cars. So if I can take a jalopy that's a rust bucket, but it still drives, it's registered and all that, and park that in my driveway, you're telling me I can't park my brand new 2024 Silverado in my driveway because it's a pickup truck? And so the rule itself, I think, is kind of strange, because I think nowadays most people recognize that pickup trucks and just regular passenger cars, what's the difference? I've seen monstrosity SUVs that are larger than pickup trucks. I mean, if I'm going to talk about what takes up space when I'm looking around like an eyesore, a mere pickup truck versus anything else, I don't see it. And I suspect that rule is written back, this rule apparently is written back in the 70s, when pickup trucks were less common as just regular daily drivers. But anyway, getting back to this, the legislature passed a law and said HOAs cannot do this. But the way it's phrased, they can't do it in documents that are drafted now or going forward from the date the law got enacted. However, depending on the language of the documents predating the law, it may or may not affect you. And that goes to the fact that underlying all of this is simply a contract between private parties, okay? And so I know a lot of people who disagree with that, and I feel your pain. I've mentioned before, I lived in a condo once, and there's a condo association, which in many respects is the same as an HOA. And I was actually on the condo board for 1 year. Just, why not? More life experience I can talk about. And we dealt with some very strange things. But we didn't go around and nitpick or fly spec every single little unit to see what's... No. What we did is we waited until somebody complained about something. And if it was bad, we'd go look at it and go, okay, that's wrong. We'd send somebody a letter. 9 times out of 10, that took care of it. But once in a while, we ran into issues, but nothing major. And I don't recall ever leaning anybody's property because of problems like this. But I do feel for somebody who moves into some place like this, and it might not have occurred to them going in that, oh, by the way, you can't park a pickup truck in your own driveway overnight. And if that's in the rules, well, I hope you find that before you move in. And unfortunately, HOAs, they're still building a lot of homes that aren't HOAs and establishing new HOAs. And the numbers are staggering in some states. In Florida in particular, it's really, really, I hate to use the word bad, but they're doing it a lot. And again, I've met people who live in HOAs who love them. Say, hey, my HOA is not bad. I like it. They make the place look clean and uniform, and I like that. Okay, there you go. But the not being able to park a pickup truck in your own driveway because of a rule that got passed in 1976, that does strike me as unfortunate. But again, when you buy into an HOA and the covenants and rules are there, when you buy in, you agree to them. And it's the same thing I've mentioned before as a general concept in contract law. If you sign a document, a contract, you're presumed to have read it, to have understood it, and agreed to it. So when you buy into an HOA, likewise, it says that it's part of the deed and all that. You're agreeing to it, and they're presuming that you read it and you understood it. And a lot of people tell me, well, I didn't read it, I didn't understand it. It's tough because in America, you're presumed to have agreed to those things when you sign in. So there you go. But a lot of people sent it. Thanks a lot. Adam Walser wrote that. abcactionnews.com. Subdivision continues fines and towing even after Florida's HOA law banning parking restrictions has gone into effect. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. You can check out any time you like, but you can never leave.